This Honorable Court of Criminal Appeals of Tennessee is now in session.
Mr. Clerk, call the next case.
State of Tennessee versus Annon, Sara, Aloqili.
I want to welcome everyone to this last case of the call of the May docket here in Jackson, Tennessee. Thank you for joining us this evening. We handle these type of arguments in the same manner that we do in person, 20 minutes to side. The appellate can reserve 5 minutes for oral argument. The panel that is hearing your case today are two distinguished judge colleagues of mine. To my right, from Murrayville, Tennessee, Judge Kelly Thomas. To my left, probably your right, our newest member of our Tennessee Court of Criminal Appeals, Judge Jill Ayers from Clarksville, Tennessee. And with that, being no preliminary matters we need to be, Mr. Appellate, it's your day and your time starts now.
Thank you, Your Honor. Good afternoon, Your Honors, and may it please the court. Patrick Rader on behalf of the appellant, Ms. Aloqili. With the court's permission, I'll reserve 2 minutes for rebuttal.
Yes, sir.
Thank you. I'm here today appealing the trial court's revocation of Ms. Aloqili's probation and asking this court to reinstate Ms. Aloqili to probation. We are appealing the trial court's finding of a violation and arguing that there was insufficient evidence by a preponderance of the evidence to support the trial court's finding, and that there was no substantial evidence of a violation in this case. At the time, Ms. Aloqili was serving a 6-year sentence on probation when on July 11th of last year, she was a backseat passenger in a car with 2 male passengers and a male driver. All the other parties in the car were unnamed at the hearing. The vehicle pulled up to a Shell gas station pump next to a white van. The white van driver and passenger were identified as Ms. Renee Williams and Mr. Joseph Byers. At some point, the 2 parties of the different vehicles get into a verbal conflict. The 3 male passengers in Ms. Aloqili's car and Ms. Williams and Mr. Byers. At the hearing, no evidence was presented as to what this conflict was about, why it started, and the surveillance videos that are available and that were presented don't have audio, so those don't help us understand what this conflict was about. But what we do know is that Ms. Aloqili stayed in the car for the vast majority of the time in the back seat, only exiting the car 3 times. The first time she exits the vehicle, she gets out of the vehicle and walks over to what appears to be an increasingly hostile verbal conflict between her friends and Mr. Byers. She walks over, stands there, walks back to the car after 40 seconds, and gets back into the car. The second time she exits the vehicle, one of her friends, a male passenger, appears to be in a physical conflict now with Mr. Byers around the other side of the van. Their arms seem to be interlocked. And so Ms. Aloqili gets out of the car that time and jogs over there and tries to pull her friend away from Mr. Byers. After that de-escalates, she goes back to the car and gets in the back seat again. The third time she gets out, the same male passenger who was in the fight with Mr. Byers had gotten into a verbal conflict with Ms. Williams at this point, and that conflict resulted in the male passenger taking Ms. Williams' wallet. And so after getting the wallet, he walks back to the car that Ms. Aloqili is in, and Ms. Aloqili gets out of the car, and they all get back in the car eventually and drive off. This resulted in a probation violation warrant being issued for her and citing her arrest and charge for robbery from this incident. And so at the probation violation hearing, the state presented 2 pieces of evidence: the surveillance video, which depicted what I just described, and then the testimony of an officer who was the investigating officer. And the officer narrated the video and testified that at one point in the video, you can see Ms. Aloqili holding the wallet, handling the wallet, going through the wallet. But if your honors watched the objective video evidence from this case you'll see that Miss Aloqili never possessed the wallet, never touched the wallet, never even, there's not evidence that she even knew that her friend took the wallet. And so the trial court nevertheless found for the state, agreed with the officer that Miss Aloqili, quote, participated and, quote, had the wallet after it was taken. So as a result, the trial court revoked her probation fully, and that's what we're here on appeal about. As this court knows, a trial court can revoke a probationary suspended sentence on probation only after having found by a preponderance of the evidence that a violation has occurred. And here, there's just simply no evidence that Miss Aloqili committed a robbery, which is what the court found she had done. Again, when your honors watch the surveillance videos, you'll never see Miss Aloqili handle, hold, go through the wallet. And as your honors know, theft requires the defendant to obtain and exercise control over the stolen property. And on appeal, the state has now acknowledged as much, has acknowledged that Miss Aloqili never possessed the wallet, never went through the wallet, like the officer testified, but it's arguing instead that she's still criminally responsible under Tennessee Code annotated section 3911-4022, which is when someone's criminally responsible for the conduct of another. But to rely on this basis, the state needed to present more evidence at the hearing. Essentially, the state needed to present evidence that she intended to promote or assist the offense, intended to benefit from the wallet, and aided or assisted or solicited the offense or encouraged the offense. But there's no evidence of any of that in the record. And the state has cited State v. Ball for the proposition that mere presence and mere companionship before and after the offense are sufficient to find that the secondary offender, if you will, participated in the offense. But this court, in that case, went on to say more than just mere presence and mere companionship. This court also said that mere encouragement is kind of the floor, is kind of the minimum of what state needs to show participation. And in this case, we don't see Ms. Aloqili encouraging the primary offender. And to go back into State v. Ball just a little bit more, that's a case where the defendant had been drinking with his buddy all day. They pull into a parking lot. His friend gets out of his car, steals a truck, and the defendant then follows his friend as they drive away, follows his friend in the stolen truck, and fails to notify the police. And yet this court found that was not sufficient. There was not enough evidence to show that he had participated, encouraged, aided, or assisted his friend in that offense to be criminally responsible for his friend's actions. And here, the evidence is even more scant. We have Ms. Aloqili, who's essentially just merely there. She's in the back of the car most of the time. She gets out 3 times. She tries to de-escalate the situation at one point, and then she gets out of the car a 3rd time. So ultimately, the statute the state is using now on appeal is really for situations where you have someone other than the primary offender engaged in material aid or encouragement or participation, which would look like, for example, the cases cited in my brief include a case where the defendant helped plan the offense, the defendant drove a getaway car for the primary offender, or served as a lookout for the primary offender. And so we don't have any of that here. And what Ms. Aloqili's actions amount to is running with the wrong crowd at the wrong time and being present when this confusing conflict happens that no one can explain. We just have this audioless surveillance video and an officer's frankly incorrect testimony. And so just to hammer this home a little bit more, ultimately, Miss Aloqili did not participate. She did not encourage. She never touched or threatened Mr. Byers or Miss Williams. She never touched the wallet. She never took any action that evidenced any shared intent with this primary offender. And it's also important to note that the grand jury ultimately did not indict Miss Aloqili for this, did not find that there was probable cause to take it to indict her. And it's important to note that this event also happened outside of her field of vision behind the van while she was in the backseat of the car. So ultimately, we would ask this court to reverse the trial court's decision to revoke based on a faulty finding of a violation, because there is no evidence of a violation here. And we would ask this court to reinstate Miss Aloqili to probation. If your honors don't have any questions, I'll rest my case. Thank you.
General?
May it please the court, Brent Sherry for the state. This case has really one piece of evidence to be considered, and that is the video surveillance tape that was submitted and viewed by Judge Morgan at the probation revocation hearing. With that being said, I would suggest that it's appropriate for the court here to engage in a de novo review to determine whether this evidence is sufficient to support the revocation of probation. And I would direct the court's attention primarily to two clips. There are 6 clips of video on this in this case, and clips 5 and 6 cover about the same period of time, but from 2 different angles at the gas station. Early in the clip, there is a physical altercation between one of these young men and the older man from the van, and that's the point where Ms. Aloqili comes trotting up to the 2 men as they're engaged. The young man has the older man by the shirt, and as she approaches, the older man breaks free and scampers around the other side of the van to get himself out of trouble. On that occasion, Ms. Aloqili, you've probably seen this in high school football games when the football players are acting tough. They come trotting up almost in a skipping fashion with their hands at their side, clenched up in fists with their arms straight, unbending at the elbows, looking tough. And that's what you see when Ms. Aloqili comes running up to these 2 men as they're engaged. As she approaches, she's not, at least my view of this video, and you can view it yourselves to see, it doesn't appear that she's trying to separate these 2 men, but she's coming up with an intent to get engaged. Later on that same clip, in clips 5 and 6, we see the altercation between, again, one of the young men and the older lady. They're talking with each other with quite a bit of animation. You don't hear anything, but you can see that from looking at the clip. And as the woman is expressing herself with her hand, she has her wallet in one hand and she's kind of waving her hands around, obviously kind of excited. And the younger man grabs the wallet and wrenches it from her hands. And as he wrenches it from her hands, that's about the point that Ms. Aloqili is getting out of the car and starting to come to his assistance. He comes around, she takes a stance, and you'll see this in the video. She takes a stance toward the older woman, defensive stance, and I would suggest an aggressive stance. And that's basically the evidence we have. I would suggest that this court simply look at the evidence and you can determine whether you think this is enough to warrant probation revocation in this case. When Judge Morgan looked at this, and I suppose we should take another look at what the standard is here. Upon finding by preponderance of the evidence that the defendant has violated the terms of her probation, trial court is authorized to order the defendant to serve the balance of her original sentence in confinement. Probation revocation rests in the sound discretion of the trial court and should not be overturned by this court absent an abuse of that discretion. A trial court abuses its discretion when it applies incorrect legal standards, reaches an illogical conclusion, bases its ruling on a clearly erroneous assessment of the proof, or applies reasoning that causes an injustice to the complaining party. In this case, Judge Morgan's final comments pretty much lay everything out for this court to consider. He notes the video does show this particular young lady. She's been identified in the video as participating, having a wallet after it was taken, getting into the vehicle and leaving immediately with those individuals with the wallet. Now, when I viewed this video surveillance, honestly, I couldn't see that this young woman actually ever had the wallet in her hands. And I don't think in good faith I can make that argument. That was something the investigator insisted upon at the probation revocation hearing. And that's all the comment that Judge Morgan made about whether she had it or not. Basically, he's just saying she's been identified as having the wallet. But then the court's finding is as follows. The court finds the burden of proof has been carried as far as criminal activities taking place while she is on probation regarding the offense of robbery. That's not as clear as one might like it to be, but obviously Judge Morgan determined that she was involved in this criminal activity. I would suggest again that the court carefully view clips 5 and 6 and determine whether you think there's enough here to show that Ms. Aloqili has engaged in criminal activity or not. Were her actions in coming up, approaching these people, coming to the assistance of her friends, is that enough to warrant probation revocation in this case? Can it correctly be determined that Judge Morgan abused his discretion? I would suggest that Judge Morgan did not abuse his discretion having viewed these tapes. But again, I think de novo review is appropriate, and I would suggest that the court take a careful look at these tapes and make an appropriate decision. As far as the decision to order her back to order her to serve her sentence, having violated her probation, if the court should agree that she did, then certainly revocation is appropriate, particularly where Judge Morgan noted that she'd had previous opportunities, she'd been revoked and placed back on probation, and here she is before him again.
I had a question about that. There was some conversation about prior violations, but was there any proof presented in this hearing about her history with probation or any prior violations?
No, Your Honor, there was not. And again, I want to be upfront and completely honest with the court. You may have noticed my footnote. The state suggested in their argument that Ms. Aloqili had been before the court 1 or 2 times before. There was no objection to that, no counter argument, and I think that that being the case, that the court could properly consider that as her being here a second time. Now, I'll point out also, there was a second violation that was initially brought with this violation before the court, but it was not pursued. So we have a single violation now, and the state had referred to a prior violation, perhaps 2, but that paperwork simply is not in the record. In any event, the state would encourage this court, again, to look at the video surveillance, consider this de novo, and make a proper determination. If there are no other questions, thank you very much.
Thank you, General. Mr. Rader, you have your full 2 minutes.
Thank you, Your Honor. Well, I would certainly agree with the state that this court needs to take a look at these videos, particularly clip 5 and clip 6, and make a decision for itself whether this would constitute robbery, which is what was alleged in the probation violation warrant. And I just want to address the 2 instances that the state has addressed in the videos. The first is Ms. Aloqili skipping towards this, skipping towards the conflict between Mr. Byers and her friend. First, whether this was a defensive or aggressive skip, I'll let the court decide. But ultimately, when she arrived at the conflict, she did not do anything aggressive or assaultive. All she merely did was grab her friend's arm and try to pull him back away from Mr. Byers. That's what I have seen in the video. That's what my view of the video is. And I'll let the court take a look at that as well. And even if this looking tough can constitute encouragement of the robbery, I would argue that it can't constitute encouragement of the robbery because this is a separate incident before the robbery ever takes place. In between this moment and the robbery, she's back in the backseat of the vehicle. And then I just want to briefly talk about the third instance where she gets out of the vehicle, and the state has said that she takes a defensive stance there. My view is that it looks like she makes a glance at Miss Williams from across the gas pump. And notably, she does not look into her friend's hands. She gets out of the car, her friend walks past her, and she looks at Miss Williams. Her friend gets in the car. She lightly shoves her friend, what appears to be annoyance or frustration at this prolonged situation between two groups of people. And he gets in the car, and then she gets in the car without ever looking. From what I recall, I don't think she ever looks down in his hands to see a wallet. And she also doesn't get out of the car until her friend is already crossing to the other side of the gas pump. So it's not like she's getting out. He's still wrestling the wallet away from Miss Williams. That's already completed by the time she gets out of the vehicle. And whatever past violations Miss Aloqili has had are irrelevant to the trial court's initial finding of a violation. Trial courts can't revoke probation without the finding of a new violation. And so that's really what the thrust of our argument is that this is not a violation. Whether this court finds that she was acting tough or trying to look tough, that alone is not a violation. And so we would ask this court to reinstate her back to probation. Thank you.
Thank you both for your presentation here this evening. This has just been a delightful day for me. It started off a little hectic with our technical issues because of our competent staffs that we have that are working with us. They kept us going all day. We wound up the court's business today. I've been on the court about 22 years now. Somewhere around in there. And without a doubt, the people that I've served with are some of the most honorable and impeccable character people that I've ever had the pleasure to serve with. And we have a new member today. Judge Jill Ayers has arrived. I wish to welcome her to the Tennessee Court of Criminal Appeals in your first day. I hope you find your experiences with this court as long as I have been here, as long as you wish to be here. And I hope you will find the colleagues that you serve with are always willing to work with you. We may disagree, but we're never disagreeable. We have some serious business to attend to. We love our work. We love our job. And in that vein, we treat each other awful lot like family. So welcome aboard, Judge Ayers. I look forward to working with you. Judge Thomas, you have any comments for Judge Ayers or advice?
I think you've said it. Just welcome aboard, and so far it's off to a very good start.
I agree. Judge Ayers, would you like to comment anything about today?
It's been a great day. I appreciate not just today, but since I've been here the last few weeks, everyone's been so helpful and welcoming. So I appreciate that. And I appreciate all the work that the AOC staff and the attorneys put in to make these virtual hearings happen. So thank you all.
And thank you all for staying with us for that. Appreciate it. Good day. We can retire to the call of the next docket. Mr. Clerk.
This honorable court is now adjourned.